Hi, this is Lawfully Creative, and this is the podcast of our law firm Crefovi. And today we are talking about the legal saga Druet versus Daniel Druet versus Mr. Cattelan, the conceptual artist. So my take on this story is that it is a missed opportunity for Daniel Druet and his legal team to capitalize on the collaborative art works legal framework, and I'm going to explain to you why now. So it's the story of a baffling legal case where neither of the parties come out on top, having lost either their reputation or money, or both in the process. Daniel Druet lost an occasion to make a splash in the art world because his statement of claims was extremely poorly drafted and badly structured, the statement of claim that is sent to the co-defendants. And Emmanuel Perrotin and Marie-Tse Cattelan came out as a bunch of amateurs, no more than unsophisticated stakeholders of a contemporary art business from this legal saga. So here's how this legal case, could have boosted the ego and pockets of Daniel Druet and adorned the respective blasons of Mr. Perrotin and Marie-Tse Cattelan. So what are the facts in this legal saga? Well, Daniel Druet is a French sculptor of wax sculptures, and in particular, he was on a retainer for the Musée Grévin, which is the Paris equivalent to the Madame Tussauds Wax Museum in London. And while he was doing all his business for the Musée Grévin and making all these wax sculptures, he was contacted by Emmanuel Perrotin, who is a Paris-based art dealer specializing in selling contemporary art. Perrotin is one of the top stalwarts in the contemporary art scene in France, in Paris in particular, and he started his gallery at 21 years old, to his credit. So he's got good intentions and he's been doing it day in, day out for a long time, but every time something legal happens, he's not very good. So anyway, Perrotin, this gallerist, contacted Mr. Druet in 1999. And according to Mr. Druet, as set out in Druet's statement of claim, it was at the request of Marie-Tse Cattelan that Emmanuel Perrotin contacted Daniel Druet. So who is Marie-Tse Cattelan? Marie-Tse Cattelan is an Italian artist with a reputation as a provocateur and outside-the-box thinker. I actually had the opportunity of meeting Marie-Tse Cattelan at the Fondation Bayeler in Basel a few years ago, and he's got a very dry sense of humor. He doesn't shy away from controversy. When I asked him about one of his sculptures, him, that we are going to mention, him being a representation of a small Hitler, he and I asked him, why did you what was the message you wanted to convey through this sculpture of this genuflexed small version of Hitler? And he was like, is this an interview? Super aggressive it was. So anyway, so yes, Marie-Tse Cattelan is definitely an outside-the-box thinker, and also someone who doesn't shy away from stunts and basically raising his profile through provocation. And Perrotin is actually Marie-Tse Cattelan's gallerist in France. Okay, so according to Daniel Druet, it was at the request of Marie-Tse Cattelan that Mr. Perrotin contacted him in order for Mr. Druet to execute several wax sculptures between 1999 and 2006. So these various wax sculptures are La Nonna Ora, for example, one of them, which is a representation of the late Pope John Paul II being on the floor, being sort of taken out by an asteroid. I don't know how you say this in English. Asteroid, so some space rock coming into Earth. And so there's also La Rivoluzione Siamo Noi, which is the second artwork made by Daniel Druet through Perrotin and for Cattelan, and it represents Cattelan, a small version of Cattelan, which is basically hung on a hanger, on a coat hanger, like this. And so you can see all these pictures actually of the various 8 sculptures made by Druet on Google Image, and I linked all the Google images on our article, which we published on crefovi.com and crefovi.fr yesterday. So there's also him, as I said, this small picture of this small sculpture of Hitler, which is genuflexed and usually facing a corner as if he had been punished by the teacher. And there are others called Frankie and Jamie, Stephanie, Betsy, etc., all made of wax, obviously. So by letters from the early 2000s, addressed to Mr. Perrotin and his art gallery company, Perrotin Gallery, Daniel Druet requested that all distribution of his artworks mention his name as the sculptor and director of wax sculptures, in the same way that the name of a photographer, author of a distributed pictures, is usually set out in a magazine. And I'm quoting here from his statement of claim. So he received no reply from Mr. Perrotin to his letters. Then between October 2016 and January 2017, the Paris museum called La Monnaie de Paris hosted an exhibition entitled Cattelan, Not Afraid of Love, which featured 4 of the previously mentioned artworks. So in La Nonna Ora, La Rivoluzione Siamo Noi, him, and the young Cattelan of Rotterdam. Together, we're going to call them the litigious artworks. There's 4 artworks we're going to refer to from now on, the litigious artworks. So again, when they were exhibited, these litigious artworks at the La Monnaie de Paris exhibition, there were no references to Daniel Druet, notwithstanding his previously mentioned remarks and requests. So arguing that his quality as exclusive author, I quote him here, of the litigious artworks was yet again unrecognized, Mr. Druet filed some summons against Mr. Perrotin and his art gallery, so the Perrotin Gallery, and as well as against Mr. Perrotin's publishing business, which is called Turenne Édition SARL, and also the French Museum La Monnaie de Paris, with the Paris High Court, which is called Tribunal de Grande Instance and was since renamed Tribunal Judiciaire of Paris, for copyright infringement as well as counterfeiting. So by acts executed by a bailiff in December 2018, La Monnaie de Paris filed some summons against Maurizio Cattelan and his Italian company Magis SRL in forced intervention. So this is a process under French law called intervention forcée, forced intervention, where you actually call a third party into a claim because you as a defendant deem that this third party has something to do with the matter at hand, and this third party's liability may be triggered, should be triggered by this court claim. So La Monnaie de Paris sent some summons to Maurizio Cattelan and his company for forced intervention, as well as a guarantee of to pay any potential legal fees due by La Monnaie de Paris to Daniel Druet through the outcome after the outcome of his legal case. And that was pursuant to the terms of the partnership loan and copyright assignment agreement that had been entered into between La Monnaie de Paris and Maurice Cattelan in the recent past in relation to that exhibition. So what were the what were the legal proceedings like? What was the procedure aspect of this legal saga? Well, the two above previously mentioned legal proceedings, so for copyright infringement and for forced intervention and guarantee, were joined by the court in January 2019, so that they would look at those two cases together. By judgment dated 28th of February 2022, the Paris Tribunal Judiciaire rejected the request of inadmissibility for lack of quality to defend raised by Emmanuel Perrotin and his gallery, as well as by Turenne Édition SARL against Daniel Druet. So in plain English, the French court and French judge decided that this case had to proceed to the trial phase and could not be just, basically terminated even before any trial, any form of trial would take place. So then it proceeded on to trial, and on the 8th of July 2022, after a hearing held on the 13th of May 2022, which I understand was a pretty brief hearing, the Paris Tribunal Judiciaire handed down its judgment, which you can have access to through a PDF attachment on our articles published yesterday on crefovi.com and crefovi.fr. So this judgment from the 8th of July 2022 set out that Daniel Druet had not reversed the lawful presumption of authorship granted to Maurice Cattelan by the provisions set out in Article L113.1 of the French Intellectual Property Code, the IPC, the French Intellectual Property Code, pursuant to which Mr. Cattelan was deemed to be the sole author of the litigious artworks, since such artworks had been divulged in the public domain exclusively under the name of Maurice Cattelan. While also the judgment said that while Daniel Druet made the wax sculptures, the litigious artworks were much more than these mere wax sculptures, and that it was Maurice Cattelan who made all decisions and gave all directives relating to the scenography, the positioning in the space, the lighting, the destruction of various pieces of furniture on which those wax sculptures were placed for each one of the litigious artworks. Moreover, the judgment set out that Daniel Druet did not file any summons against Maurizio Cattelan. Therefore, he could not argue in such legal proceedings about some rights aiming at evicting Maurice Cattelan from the benefit of a presumption of ownership without Mr. Cattelan being part of those proceedings. In addition, the judgment mentioned that Maurice Cattelan was not a principal defendant to the joint proceedings, but was only brought in as a guarantor and forced intervening party for La Monnaie de Paris, the French Museum. Therefore, no legal nexus was created by such forced intervention between Daniel Druet and Maurice Cattelan. Consequently, the judgment went on, and since Mr. Druet did not file any summons against Mr. Cattelan, this presumed author of the litigious artworks, against who he argued the ownership of the rights on the litigious artworks, Daniel Druet must be declared inadmissible in all his claims for copyright counterfeiting. And finally, the warranty claim raised by La Monnaie de Paris against Maurice Cattelan and his company Magies, SRL, without any cause, would not be reviewed. So that was, in a nutshell, the various arguments set out by the three French judges who handed down the judgment on the 8th of July 2022. In its judgment, the tribunal sentenced Daniel Druet to support his own expenses and legal costs, of course, but also to pay 10,000 euros to Emmanuel Perrotin, his art gallery and Touraine edition Sahel, as well as another 10,000 euros to La Monnaie de Paris, pursuant to Article 700 of the French Civil Procedural Code. Mr. Druet also had to pay full costs to the law firm of Mr. Perrotin, his art gallery and Touraine edition, pursuant to Article 699 of the French Civil Procedural Code. So what information, what is the substance of this case, and what can we understand from it and in a thorough analysis? Well, Mr. Druet needs to reverse the authorship presumption first and foremost. While I was reading the judgment and the legal arguments developed by the claimant, so Mr. Druet and his counsel, Jean-Baptiste Bourgeois, I was baffled by the lack of legal sophistication of such arguments. Firstly, Mr. Druet alleged in his statement of claims that he was the exclusive author, I quote him here, of litigious artworks, as if his litigious artworks were solely constituted by the wax sculptures made by him under the directives of Mr. Cattelan. In this day and age, a large portion of contemporary art is made up by conceptual art. Conceptual art is a branch of modern art and contemporary art, which is defined not by the aesthetics properties of the artworks, but solely by the concept or ideas of art, which, with the ready-made created by Marcel Duchamp being the epitome of conceptual art. So nowadays, a large portion of contemporary art is made up by conceptual art, where basically the art is mostly the idea, the emotions that the artwork conveys. Mr. Cattelan is recognized as a master of conceptual art, whose artworks are mostly valued for the message and as well as the emotions that they convey or trigger in the viewer, rather than the aesthetics characteristics of such works. Most telling is the controversy and mixed emotions created by one of the litigious artworks, him, so still this sculpture of Hitler in a small form, like in a child form, when it was exhibited in Warsaw's Jewish ghetto, while it represents the small version of the anti-Semitic dictator who attempted to erase the Jewish race from planet Earth before and during World War II, Adolf Hitler, with many of the killings taking place in Warsaw's ghetto at the time. So that really triggered a big controversy when Cattelan exhibited him in the Jewish ghetto of Warsaw. So that is an example that shows, you know, this sort of punchy strategy that Cattelan has, which is the basis of conceptual art. Mischievous Maurizio Cattelan conveys a message, triggers violent emotions via his artworks, a lot of which are not made up of wax sculptures, such as Trotsky's Ballad, made in 1996, and Naturalized Male Ostrich, made in 1997, which are based on taxidermied animals, so a horse for the former and an ostrich for the latter. Or Love, L-O-V-E, made in 2011, which is an 11-meter white marble sculpture middle finger, sticking straight up from an otherwise fingerless hand, pointing away from Borsa Italiana, so the Italian stock market in Milan. Okay, so it's basically a middle finger sticked up and made of white marble. Okay, so Cattelan uses other channels, other medium to create his artworks. Not only wax, he also uses taxidermied animals as well as marble. Therefore, Mr. Druet claims that he may be the sole and exclusive author of the 4 litigious artworks. They don't, you know, hold muster. They don't hold water, and denote a complete lack of understanding or desire to understand conceptual art. Secondly, even the judges in their judgment from the 8th of July 2022 were actually more understanding of what conceptual art is than Daniel Druet and his counsel. It was just baffling. Well, they suppose these three French judges are supposed to know almost hardly anything about art, contemporary art, and conceptual art. So, secondly, Mr. Druet and his counsel did not file any summons against Maurice Cattelan directly. They filed only against this art dealer's gallery business and art book publishing business. So Emmanuel Perrotin Gallery, and Turenne Publishing SARL. What a rookie's mistake. It's always better to file summons against more people than less people. And that was such a rookie's mistake to actually not include them. It is evident that if one's legal claims are that one is the author of an artwork in lieu and place of someone else, one must file some summons against that someone else who has a presumption of being the sole author of that artwork in court. This lack of summons against Maurice Cattelan by Daniel Druet and his counsel did not deter them, though, from requesting in their statement of claims Maurice Cattelan to pay Daniel Druet the sum of 100,000 euros for damages in alleged breach of a right to authorship of or paternity of the litigious artworks, as well as always associate the name of Daniel Druet with the litigious artworks and the penalty of 5,000 euros by infringement observed, and set out on all media of any nature, and in particular on the sites perrotin.com and store.perrotin.com and on monnaiedeparis.com the name and quality of offer of Daniel Druet upon the distribution and reproduction of the litigious artworks, jointly with Emmanuel Perrotin, his art gallery, Édition Turenne, and La Monnaie de Paris. So this is just baffling. Daniel Perrotin and his counsel don't file some summons against Maurice Cattelan. However, in their statement of claims, they still ask Maurice Cattelan to actually comply with their requests set out in the statement of claims. It doesn't make any sense. I mean, if his counsel is a professional lawyer, I don't know what he's been doing for the last 50 years of his legal career, to be honest. This is just rookie's mistake, like basic rookie's mistake. This lack of basic understanding of the French civil procedural code and rules is so gross. It is actually shameful that a Paris lawyer, the bar to which I also belong in France, allegedly steeped in intellectual property, was even allowed to send such a statement of claims to the Tribunal Judiciaire de co-defendants. Of course, it was very easy for the co-defendants and their counsel to eat Daniel Druet and his lawyer alive in their response to the statement of claims, les conclusions en réponse, especially since Mr. Druet and his counsel disregarded a cornerstone principle of French copyright law enshrined in Article L113.1 of the French Civil Intellectual Property Code. The quality of offer belongs, except in case of evidence to the contrary, to the persons under the name of which the work is disclosed. Okay, so there is a presumption that the person under the name of which the work is disclosed is the author. Okay, if Mr. Druet wants to have any chance to win this case at all, first he must demonstrate that such presumption that Maurice Cattelan is the author of the litigious artworks can be reversed. Since these works were disclosed solely under the name of Maurice Cattelan as author. That requires skill and a thorough knowledge and understanding of copyright law. Mr. Druet could argue and prove that Maurice Cattelan never gave him any directives and instructions to create the wax sculptures used in the litigious artworks. He could even say and prove that he never had any dealings and contacts with Maurice Cattelan or communications going through Emmanuel Perrotin and his art gallery, which would further show that there was no subordination link and therefore no employer-employee relationship, or not even a principal and contractor relationship between Mr. Druet and Mr. Cattelan. Daniel Druet could also argue, in order to reverse this presumption of authorship, that he is the sole author of the wax sculptures, which, along with other creative elements provided and decisions made by Maurizio Cattelan, such as the scenography, the lighting, the destruction of pieces of furniture on which the wax sculptures were placed and displayed, would constitute the litigious artworks. So by that, I mean that Daniel Druet could say, yes, I made the wax sculptures and I am the author of the wax sculptures. However, the sculptures, the litigious artworks, are more than just these wax sculptures, because they comprehend, they cover more than just the wax sculptures. They cover also the scenography, the arranging of the display, the lighting, and also the destruction of pieces of furniture on which the wax sculptures were placed and displayed. And therefore this comes to the collaborative artwork. And so this is where I think Mr. Druet should bank on being a co-author in a collaborative artwork, as opposed to claiming that he's the exclusive author. Because saying that he's the exclusive author doesn't hold water. I mean, Cattelan has done also, and most of the work. He's come up with the idea, he's explained everything that had to be made to Daniel Druet, is conceptualized the whole thing. So I was also baffled to read in the judgment from the 8th of July 2022 that Daniel Druet and his counsel never thought it necessary to clarify that the litigious artworks were collaborative works, i.e. some works which creations were made jointly by several natural persons, pursuant to Article L113-2 of the French Intellectual Property Code. This more realistic assertion would have automatically granted Mr. Druet the status of co-author of the litigious artworks, and allowed him to claim a share in the royalties earned on the exploitation of a copyright by Maurizio Cattelan and his gallerist Emmanuel Perrotin, in particular on the reproduction right used to publish the catalogue of the exhibition at La Monnaie de Paris, probably also some postcards and potentially, some sort of stationery, and all other merchandises featuring the litigious artworks. So through that, if you had said, I'm a co-author in a collaborative artwork, you would have said, I want to have a share of the royalties. That would have been a much more sensible and, financially remunerative approach. But no, he didn't do that. Well, Mr. Druet and his counsel made a show in their statement of claims of requiring the co-defendants to, I quote here, provide all documents and informations that they held, allowing to value the economic prejudice of Mr. Druet, i.e. the number of visits to the pages of the internet website .perrotin.com in the last 5 years, the number of visits to the pages of the internet site .perrotin.com specifically targeting dedicated to Mr. Cattelan during the last 5 years, as well as disclosing the commissions received by Mr. Perrotin and his gallery during the last 5 years in lending and selling works created by Mr. Druet and attributed to Mr. Cattelan, as well as information on the turnover made by Mr. Perrotin, his gallery and his publishing business, Turenne Edition, on the sale of books and artworks in relation to Maurizio Cattelan from the store .perrotin.com during the last 5 years. Actually, Daniel Druet and his counsel never demonstrated and gave any evidence that Mr. Druet was a co-author, let alone the exclusive author of a litigious artworks in the first instance. That doesn't make any sense. No wonder that the judges were tough on Daniel Druet, sentencing him to pay 10,000 euros to each co-defendant, except Mr. Cattelan and his company Magis SRL, who did not ask for such compensation under Article 700 of the French Civil Procedural Code. So this will teach Mr. Druet and his counsel a hard lesson, because issuing such statement of claims, which is so clearly devoid of any sound legal reasoning and arguments, and completely lacks any evidence relating to any of his unsound legal points, is just a waste of everybody's time, money, and energy. And yet, another way to suffocate the court docket of the Paris Tribunal Judiciaire, which is still trailing a backlog of pre-COVID-19 cases to adjudicate in its midst. So I doubt that Mr. Druet will appeal and or use the services of the same lawyer should he decide to pursue his claims of copyright infringement against Mr. Cattelan. However, the lesson for the co-defendants and artists such as Mr. Cattelan in particular is that they need to put in place contracts, yes, with their contractors and freelancers before instructing them to do any work, which explicitly, clearly, and transparently set out who owns the copyright of any artwork or part of the artwork created by the freelancer, the contractor. In this state of affair, Mr. Perrotin, his gallery, and Mr. Cattelan come across as a bunch of total amateurs who dabble in the art business like mischievous schoolboys through and through, and that tarnished their reputation in the process. Why don't they have any contracts in place? Hello, this is the 21st century. This comes back to the message I have conveyed time and time again with respect to the art sector. First, in relation to art auctions and the ongoing issue of mismatch in pre-sale descriptions, and second, about the use of arbitration to improve the security of art sales and transactions. Contracts must be systematically drawn in a clear, transparent, and straightforward manner and signed by all parties before and concomitantly to any art transaction taking place. On this note, I am done, and I thank you very much for your attendance. If you want to read the written version of our thought leadership content, do have a look at our latest publications on crefovi.com/store. You can actually subscribe to a £100 membership there if you want to read the content in English. And should you prefer to read the written content in French, you can go on crefovi.fr/magasin and subscribe to our €100 annual membership fee to do that. On this note, thank you, and I shall see you soon. Bye for now.